compensated in front of your body or in front of the state if it was something that you had some level of participation in. The way I think the State Ethics Commission talks about participation is, did you have your fingers in it? You know, did you touch it? That's the phrase they use. Sometimes that's easier for people to understand than just what does it mean to participate. Then there's former trustees. So when you leave service, I guess you're all new board members, but when you leave service as a trustee, your obligations under the state ethics statute have not ceased. There is a lifelong ban on ever being compensated with respect to a particular matter that is integrally related to something that you did as trustee. You know, if you worked on something as trustee and you participated and you now want to go work for a company that, you know, is the other side of this transaction, you can't. It's integrally related to what you did as a trustee. That's a lifetime ban.
From coming back to that original school, you could go work for another company and go sell it at other schools.
Absolutely, right? Absolutely. Yeah. And you can even sell to your own school as long as it wasn't something that you participated in that is integrally related to your participation. So whatever you do now will have impact on what you can do later, or it may. This prohibition also applies to the business partners, you know, of the former trustee. They also can, but only for 1 year. So after a year, there may be things that you can't do, but your partners can do. Right? So that's a way around it. I think these lifetime bans can be a little bit difficult. And for a year, as a former trustee, you still cannot represent somebody else in connection with the school. If you had if it was something under your official responsibility during the prior 2 years, and it's something the state has a direct interest in. This notion of representing doesn't come up all that often, I think, in the charter school context. But it can if, for example, a child has an issue with the school, and as trustee you are involved in some kind of I don't know, oversight of discipline or overhauling of a discipline program. That's a situation when you might want to represent a student, and you might not be able to. Or similarly, as trustee, if you were involved in setting up a special ed program, you may not be able to represent a child with special needs vis-a-vis the school for a year after service as trustee. If you were directly involved, the school has a particular interest in it. Those are some examples, but I think it doesn't come up all that often. Okay, now we get to the financial interest question, which is yours. This is one that comes up a lot, not just in curriculum, but in many different ways. And some of them are a little bit surprising. Okay, this is page 3, it's part D, and there is a disclosure form at the end, which we'll talk about, because this is one of those sections where disclosure and getting permission might save the situation. So you cannot participate as trustee in any matter in which you have a reasonably foreseeable financial interest. All of these words are laden with meaning. What does it mean to have a reasonably foreseeable financial interest? Well, sometimes that can mean evaluating a competitor of your company, which is a tough one, right? It's not just your company you're evaluating now, it's a competitor. But if your competitor doesn't get the contract, then you might not get the contract either, but it's your competitor. They won't be doing as well. Their revenues will be down. So you have actually a reasonable foreseeable financial interest competitors, not only in your own direct financial interests. Participation in a matter affecting financial interests includes not only your financial interests, but also those of your family members. For this purpose, we're looking at immediate family members and your parents-in-law. But apparently your brother-in-law is okay, your sister-in-law, that's okay, they're not listed. but your brothers, your sisters, your own parents, your children. I think not your grandchildren either. You know, every time any statute talks about family, it has a specific meaning. This is the meaning under this statute. Again, business partners. You know, so the state is concerned about your participating in a matter in which your business partners have a financial interest. And this one's a little bit hard for people. Of any business organization that has a financial interest in something you participated in, and you have a connection with that business organization. So that's not just a business partner, because the State Ethics Commission says that that term business organization in the statute can include a nonprofit. So you may be serving on the board of a nonprofit. That's not uncommon for members of boards of trustees of charter schools. They may have other civic affiliations. If that nonprofit has a contract with the school, that's a financial interest of a business organization in which you are a director in something that you might participate in as a trustee. And that can be problematic too. For this purpose, business organization includes a nonprofit only if it's the kind of nonprofit that actually engages in some kind of activity or business. So if it's just a nonprofit that does advocacy work or that does grant funding, that might not be a business organization. But if it's a nonprofit like the YMCA, and you're trying to set up some kind of gym activities at the YMCA, and you're on the board of the YMCA, that might be a business organization, and that might be a problem. Even though you're not personally benefiting, I think everyone would agree that there's, you know, the YMCA is a wonderful organization. It's probably not taking more money than it needs. That actually can be a problem under this statute. So, how do you get around this statute? Full disclosure to your appointing authority. In your case, that's the Commissioner of Elementary and Secondary Education. And we'll get back to you in a minute, because you may have two appointing authorities. And the appointing authority then takes one of three actions, two of which are probably not relevant to trustees, which is assigning the matter to a different person. So that's never going to happen. Assuming responsibility, again, not going to happen. And the one that's really relevant to trustees is that the commissioner then agrees that the interest is not so substantial as to affect the integrity of your service. So to go back to your curriculum question, what you would have to do is make a dispute if the school was in fact, you know, contracting for the curriculum, and you participated in the matter, in the adoption of the curriculum, you would have to file a disclosure with the Commissioner of Elementary and Secondary Education, and the Commissioner would have to sign off on the idea that your financial interest was not so substantial as to affect the integrity of your decision making. So, you know, if it's only $1, might not be. Right? So there's no real bright line there. There's no $50 rule, but that is what you're looking for. And I included at the end in its attachment B, it's right after that form that would be filed as you began service as a trustee. It's disclosure of financial interest, and it asks you, who you are, what, for the name of the organization. And then the next form after that is the determination form, which is the form that the commissioner would then sign, saying that it was, it says attachment B. Yes, that's the determination. And that would go on file with the State Ethics Commission.
So that's for state employees, including special state.
Including special state employees. In fact, it really is only for in some circumstances, yeah.
For special ones.
So in some circumstances, it would only for special ones. Yeah. And that's something that that you would need to think about as well.
So, just to clarify, there's this form here
Disclosure,
us that
yes.
we get
All of it.
involved on
And
this.
you do that every year.
And we did it, we've done it annually, did
Yeah.
it this fall.
That's right.
But is there some other form you were just referring to?
Yes, okay, so that form, the form that you do annually, is for everything that happened in the past year.
Yeah.
But if what you're trying to do is make a disclosure and get a determination to permit something going forward, would be this form right here. Oh, I'm sorry, we're missing. Here, first this form, this is what you file. This is the disclosure of the financial interest, and then the determination is made on this. And then you can see there's a little check off, A, B, and C. Which is, A is I assigned it to someone else, B is I took responsibility for it, and again, that's really not going to happen in the circumstances of a trustee, and C is I've made the decision that it's not so substantial, and that's the one you'd be looking for. All right, so that covers participating in matters affecting financial interests. Okay. Now we have financial interests in state contracts. So this is another one that oftentimes people don't realize can be an issue. Not only is the state ethics statute concerned about your interests in state contracts or state where your interests where you personally have involvement, but it's actually concerned about any contract made by any state agency if the state is an interested party and you have a reason to know that the state has an interest. And that's very long-winded, but an example of this is states issue bonds. And sometimes people buy bonds or buy state bonds. And that is a contract in which the state has an interest. And clearly you are aware that the state has an interest. And the state ethics statute might be interested in that.
But wait, you mean if we're bond salesmen?
If you're bond purchasers.
If we're bond purchasers?
Yes.
Investors.
Investors.
Oh.
Yes, yes. Now here, this is one where there's a list of exceptions.
Percentage ownership.
Right, so that's why I said bond. Because the percentage ownership rule only applies to corporations. And I don't think as yet the Ethics Commission has issued a ruling on ownership of bonds.
Especially state bonds.
What?
Especially state bonds.
State bonds, exactly.
So you have a synchronized interest instead of a...
Yeah, exactly. So, it's a little complicated. We looked at this for a client a couple of years ago. At the time, we were speaking with the State Ethics Commission. They really are very, very helpful. And they invited us to submit a request for an opinion. But the client wasn't interested in paying for that. So I don't think it's happened yet. I'm sure that if somebody puts in a request for an opinion, the state will decide that it's really like corporations. And if your interest is so minuscule, that's going to be okay. Because where this really comes up is not so much you're the bondholder or the particular bond, but in your portfolio you might have a mutual fund that holds interest in state bonds. Anyway. In the meantime, though, until we get that opinion that says that's okay and that the state doesn't care about it, so we have on page 6, there's a bunch of exemptions, to the prohibition. So one is the first one is the one you mentioned, ownership of less than 1% stock in a corporation. The second one is the one you wouldn't like, which is you figure it out within 30 days, you disclose and you dispose of the interest. That's, I find, not very helpful, but it's there. The third is the one that most people would rely on, which is, well, you didn't have any official responsibility for the bond. This is the third bullet point on page 6. And you filed a disclosure statement with the State Ethics Commission, making full disclosure, and that should be fine. And then there's the fourth bullet point there, which is you filed, and the government gave you an exemption. And that doesn't happen that often, but I work around my phones. And so I did include, actually, as an attachment in here,